Welcome to Pass Law Exams. Today's tutorial is on intention to create legal relations, part of our contract law series. Let's get into it. A daughter gives up 2.5 years of her life to care for her elderly mother. The mother dies. The estate refuses to pay. Was there a contract? In Rogers v. Wills, decided in 2025, the High Court said, yes. A rare but powerful finding of contractual intention in a domestic setting. Now consider this. Parents lend their son over £600,000. He buys a house. He buys an investment property. Then he refuses to repay. His defense: we are family. It was never meant to be legally binding. In Barry v. Barry, decided in 2024, the High Court said, the presumption can be rebutted. Pay it back. 2 cases, 2 families, 2 courts saying the same thing. The law does not simply walk away because the parties are related. So what is the rule? The doctrine of intention to create legal relations asks one question. Did the parties intend their agreement to be legally binding? The test is objective. Courts do not ask what the parties secretly thought. They ask what reasonable parties in those circumstances would have intended. The law draws a clear distinction between 2 categories of agreement. In domestic and social agreements, the presumption is that there is no intention to create legal relations. The leading authority is Balfour v. Balfour, 1919. A husband working overseas promised to pay his wife £30 a month. The marriage broke down. She sued. The Court of Appeal refused her claim. Atkin L.J. held that domestic agreements, commonly entered into, are outside the jurisdiction of the courts. As a matter of public policy, every house is a domain into which the law does not seek to be admitted. But that presumption is rebuttable. In Merritt v. Merritt, 1970, the husband had left his wife for another woman. They met. They signed a document. He would transfer the matrimonial home to her name once she paid off the mortgage. She did. He refused. The parties were no longer living in amity. They were separated. They bargained keenly. The presumption did not apply. The agreement was binding. A similar result followed in Jones v. Padavaton, 1969, where the court found no binding contract between a mother and her adult daughter. Applying the same reasoning as Balfour, the domestic presumption stood because the evidence did not rebut it. In commercial agreements, the position is reversed. Courts presume that an intention to create legal relations is present. See Esso Petroleum versus Commissioners of Customs and Excise, 1976. That presumption too can be rebutted, as in Rose and Frank Company versus J.R. Crompton and Brothers Limited, 1925, where a commercial agreement expressly stated it was binding in honour only. The House of Lords gave full effect to that clause. The message from Rogers v. Wills and Barry v. Barry is clear. The domestic presumption is not a rule of law. It is a rebuttable presumption of fact. It is always a question on the evidence. The relationship between the parties is one factor, but it is not the only factor. Conduct, written terms, the nature and scale of the arrangement, all of it matters. Before you go, your recap. 1. Domestic and social agreements are presumed not to create legal relations. Balfour v. Balfour, 1919. 2. That presumption is rebuttable on the facts. Merritt v. Merritt, 1970. 3. Commercial agreements carry the opposite presumption. Intention is presumed present. Esso Petroleum v. Commissioners of Customs and Excise, 1976. 4. The commercial presumption can also be rebutted. Rose and Frank Company versus J.R. Crompton and Brothers Limited, 1925. 5. The test is always objective and context-specific. Rogers v. Wills, 2025 and Barry v. Barry, 2024. Write those down. Know those cases. Apply those principles. Want to test your knowledge? Visit us at passlawexams.com. Past paper questions, model answers, and everything you need to prepare. Pass law exams, because passing is the only option.